My topic that I was asked to speak originally was on corporate governance and SFIO, but then when I had a look at the list of speakers speaking before me, everyone seemed to be broadly covering it, whether it's a case of independent directors, duties, responsibilities, related party transactions, intercorporate loans. I spoke to Mr. Ravi yesterday. Would you mind if I spoke on what are the kind of questions that our clients have been asking us over the past 2 months, ever since the Companies Act came into force and ever since the rules came into force? And many thanks to him. So the topic that I'm covering today is basically practical implications of the changes to the Companies Act. Yes, unfortunately, like most of the predecessors before me, I'm also going to be posing a whole bunch of questions which the panel can answer. I'm hoping to introduce the definition of control. The sum and substance of the definition is basically any shareholder who has a right to control the management or policy decision of a company, which would include through a voting arrangement or a shareholders agreements in any manner, would automatically be deemed to be in control of the company. The next logical step of this definition is the fact that any person who's in control of a company is deemed to be a promoter of a company. If you, that's the next slide. The person is automatically deemed to be in control of the company. If you see the subclause 3 of 269 of the 2013 Act, it very clearly says promoter is a person who has control over the affairs of the company directly or indirectly as a shareholder, director or otherwise. There are a whole bunch of issues surrounding just this. Minority shareholders who have veto protection rights in a company could be deemed to be in control. Pooling arrangements that promoters typically enter into with minority shareholders could be deemed to be in control. Thankfully, at least they've of control. Why is this so important? Again, just by way of background, the Companies Act 1956, promoter was typically only used in the context of civil liability for misstatement in prospectus under section 62, I think. But under the new act, the liability and the responsibilities on the promoter, therefore logically meaning every person who's deemed to be in control of the company has been extended. Whether it's a simple act for a civil liability for misstatement in prospectus, misstatement in incorporation related documents, liability for misstatement of non-compliance with the norms and explanatory statement, liability for contravention of private placement norms. And I'm going to talk about the private placement norms in section 42 and 62 also in detail today. So the liability of promoters is not just limited to the prospectus anymore, but it actually extends to basic corporate actions of the company, including certain secretarial actions. Definition of control, some further implications. The definition of control also flows into the definition of holding and subsidiary relationship. It very clearly says that who controls the composition of the board of directors. Under the old Companies Act, the definition was quite straightforward and simple. There was also a certain exemption that was there where you could actually structure whereby the voting capital was different from the economic interest in the company. But under the new framework of control, it's possible that a parent could hold 90% shares of a subsidiary, but voting power or veto power is given to another person, and therefore the subsidiary effectively has two parents. I really don't know how they're going to impact consolidation. From a control perspective, can a subsidiary have two parents? But the Companies Act seems to imply that at the moment it can. Just jumping quickly back to some of the key issues that I touched upon. The test of control is essentially a subjective test. Like I said, mere execution of shareholders agreements, veto arrangements, all of those will form the definition of control. Sorry. Thank you. If one were to pause out here and see how SEBI's view is in this and whether that has any bearing on the AMCA view. SEBI in Shubham case a few years ago actually decided that veto is not subject matter of control and therefore it has to go on further. The case went on to the Supreme Court, but the Supreme Court did not decide on the position of law. Actually, to the contrary, it said that we are not deciding on the position of law. So from a legal perspective, how control is to be determined is still open to interpretation. The Companies Act 2013 also specifically has the provision of entrenchment, which basically says that a higher threshold than that what is prescribed in the Companies Act, if put in the Articles of Association, would be applicable to the company. Typically what we do is we replicate provisions of shareholders agreement into the articles of association of the company. Would that amount to control? The next question that we've been asked in the context of the Companies Act and the new rules is, what do we mean by 186.1? And I know a whole bunch of you have questions surrounding that, and I'm happy to take that also. The point is very simple. This is a direct fallout of the cute and innovative structuring that lawyers and other advisors have been doing over the past few years, where investment is structured through multiple entities. Whether we're talking about the Sahara case, whether we're talking about a whole bunch of other cases. The government has decided that we don't want structures like that anymore. We need clean, simple structures where you cannot have more than 2 investment companies. I saw there was a question in the book itself as to what do you mean by the restriction under 186.1. The restriction is very simple. You are allowed, companies are not to make investments through more than 2 layers of investment subsidiaries. By way of background, this has also been the position of the RBI per se. This has been the position of the RBI for the past 2-3 years. This is an extension of the same thing. I know the RBI is more concerned with foreign exchange and not necessarily with the Companies Act, but the principle is being same. Basically, the Indian government is saying we want clean structures. Corporate India has been doing a lot of structuring which we are not comfortable with. We want to put a stop to it. That's the simple message that are there. They've given 2 exceptions to this. One is if you're required to acquire companies outside India, which automatically falls within the RBI domain that I just spoke about. And the second is if for regulatory compliance, you're required to have more than 2 levels of structuring. Investment companies, they haven't defined investment companies. It only talks about principal business of acquiring securities. Again, the only non-definition that I know of, at least in terms of principal business, is in the definition of NBFC, where I use the 50-50 test. Are we supposed to export the same definition into the Companies Act? Is a question that's on top of all our minds. Section 90 of the old Companies Act has been done away with. As innocuous as that deletion may seem, unfortunately, Section 90 of the old Companies Act had a very specific exemption for private companies. The implication of that now is the fact that preference shares, which we could earlier structure around, or private companies which could have differential voting rights, have now been done away with. Further on, the new Companies Act very clearly specifies that even for private companies who want shares with differential voting rights have to satisfy the eligibility norms which are earlier under the old Companies Act applicable only to public companies. So in effect, you need a 3-year track record of distributable profits, specific authorizations in the MOA, no default in filing financial statements, not having been penalized by the court in the preceding 3 years for offences under RBI, SEBI, SCRA, FEMA, etc. I would presume that this would also mean by the MCA or by the ROC. Like I was saying earlier, typically for private companies, the position was the fact that voting would be on a fully diluted basis. Whether you had preference shares or equity shares, you would consider voting on a fully diluted basis. That's not the case anymore. Now voting is purely on the basis of the equity shareholding. The preference shareholding would not be taken into account for the purpose of voting capital. Again, from a deal structuring perspective, where investors are coming in, they're looking at purely preference shares instruments for obvious reasons, because a preference share has liquidation preference and preferential right to dividend. That route sort of is under question right now. There is no ready-made answer as to what's the best analysis for this. It's probably got to be done on a case-by-case basis. Each investor, each company will have to take a call as to what it is comfortable with. To give you a simple example, a promoter holds 100 shares in a company, an investor holds 1 lakh preference shares in a company. The investor with 1 lakh preference shares has no voting rights in the company effectively. In a private company I'm talking about. We always had that of the Companies Act, but effectively where we are today, that means the promoter can typically hold investors to ransom because the promoter has the entire voting capital. An issue we're still grappling with, at least in the legal industry, is this entire process, procedure, dichotomy, if I can call it that, between Section 42 and Section 62 of the Companies Act. Section 42 talks about private norms, private placement norms. Section 62 talks about preferential allotment. To put it in context, private placement, at least the way we are reading the regulations and the rules, is a very straightforward process where it is envisaged that the company is issuing an information memorandum. It is a serially numbered information memorandum which can only go to a select group of individuals between 50 and 200 in any financial year. As opposed to a preferential allotment, which to define it under the concept of the old Companies Act, is a plain simple 81 one-year resolution. Difference number two, the private placement memorandum is a document that you're sending out looking or seeking for potential investors. That is the invitation to offer that is happening to go on the provision of Section 67 of the old Act. Is the invitation to offer, the invitation to subscribe. The new rules and regulations are seeking to try and curtail that entire process, because there have been a number of instances before the ROC where documents have been issued to more than 200 people, more than 300 people. This is all in the context of the fact that the restriction under the old Act was 49 people under Section 67. So you have an information memorandum that's been issued to 200, 300 people, which technically should be a public offering under the old Act. So to curtail this unregulated or unabandoned method of seeking capital to my mind at least, is a very concerted and definitive move by the regulator to create a distinction between a private placement process where a company doesn't have an identified set of investors or potential investors. It is going to the market on the basis of a private placement memorandum, which will have disclosure. We can talk about the disclosure, but the disclosure is quite exhaustive. It's almost like a prospectus pretty much. You talk about the MD&A, you talk about the risk factors, you present the financial statements. It's a very definitive process. Pref allotment again is a simple case where you have an identified investor, one or more persons, and you make a specific 81(1)(a) equivalent resolution to them. Just in terms of the process, in terms of the private placement, you do require a special resolution now, irrespective of whether public or private. There's a Pass 4 that has to be filed for it, which is the new form. Like I said, it requires detail. It's almost like a prospectus or I would say like a QIP document. Investment size of not less than 20,000 of value per person. Again, if you're doing a formal process when you're reaching out to the public, the government thought fit that you should have a certain limit below which you should not be doing a private placement process. So if you want to do below 20,000, it seems to indicate that necessarily you would have to follow the preferential allotment route and not the private placement route. Allotment has to be made within 60 days of receipt of application money. I was reading the questions again in the brochure, and I saw a question there as to whether money not paid within 60 days, how would that fit in with the company's acceptance of deposit rules 2014? If I'm not mistaken, I think there's an explanation in the rules which clearly says that so long as it is paid within those 60 days, it won't tantamount to a deposit. But anything after that, it would obviously tantamount to a deposit. I think that's the only way to read both of them together, and I think there's an explanation in the rule which supports that view. I've already touched upon preferential allotments, but just to quickly run through it, like I said earlier, it's equivalent to the 81(1)(a). We do need a special resolution. It's applicable to equity shares, convertible debentures, or convertible securities. The exemptions for private companies that were there have been withdrawn. The tricky bit in Section 62 is the fact that when you're issuing convertible instruments, under Rule 13 under Chapter 4, it very clearly says that the price at which the instrument is to be converted has to be specified upfront itself. Typically, the way, at least in our experience, we've seen convertible instruments issued is there could be a band, or conversion is dependent upon a number of trigger events, whether it's the company reaching a certain financial milestone or the company's revenue, so on and so forth. How do you issue convertible instruments today for a private company where you're supposed to determine the price upfront? The entire point of having a convertible instrument linked to certain triggers or parameters, whether it's an event of default situation or whether it's an EBITDA revenue situation, is all put into question by the simple rule out there, I think it's Rule 13 in Chapter 4, which very clearly says that the price has to be determined upfront. More importantly, in terms of the process to be followed, your preferential allotment process does necessarily need to follow the private placement rules under the rules framed under Regulation 42. Quickly to touch upon transferability of securities of public companies. Earlier, 111A only spoke about shares and debentures. The New Companies Act has extended that to securities, which would necessarily mean that derivatives, forward shares, options, so on and so forth, as defined in the securities contract rules, are all now freely transferable. The advantage of this is that there was always a dispute, so to say, which has actually gone to the courts also, as to whether provisions of restriction on transfer of shares between two shareholders were they ever enforceable. This was decided by Pesso's holding case. The principle of the judgment has now been enshrined under the Companies Act itself, under Section 58(2). So the position of law on that front has now been settled very clearly, that a contract or arrangement between two or more persons in respect of transfer of shares is now enforceable as a contract. What they haven't gone on to say is that do you need the company to be a party to that contract for it to be enforceable against the company? So I would assume that the logical view to be that if two of us are entering into a contract, we should make the company also a party to the contract, and therefore you have statutory protection in respect of the free transferability of shares. I think the earlier panel presentation were talking about the definition of person not having been defined. That's absolutely correct. Person for all practical purposes under the Companies Act could mean anyone, whether it's a company, holding, subsidiary, independent person. The definition of person is all the more important in the context of 185, 186, which we'll also discuss just now, because even loans to persons who are interested is prohibited. Employee stock options, they've actually codification of law on ESOPs for private companies. 1956 Act was very clearly limited to sweat equity shares, but now it is very, very clear. Promoter or persons belonging to the promoter group or directors who hold more than 10% are not eligible for stock options anymore. Again, it's what was there under the SEBI guidelines in some form. They've actually distilled it down and said, we want greater regulation, we want lesser conflict of interest, so therefore the stricter requirements that were there for listed companies, for public companies, is now also applicable to private companies. There's a prohibition now on forward dealing of contracts, where it clearly says no director or KMP shall buy in the company or holding company or associate company or put and call option. Put and call options are an extremely important structuring instrument when you're doing private equity investment or trying to raise capital, because from an investor's perspective, the promoter is the buck stop. It is basically the last man in the game. The fact of the matter is now, if a promoter is a director, which in my view at least 99.99% of the cases, the promoter will be the director of a company, the entire concept of the investor having a put option on the promoter in the case of an event of default or in the case of the company not achieving a certain business or redemption of instrument, all are, to my mind, not allowed under the New Companies Act, full stop. And it's just not a question of trying to structure around it, because the penalty for contravention of this is extremely high now. It's imprisonment of 2 years or a fine between 1 lakh and 5 lakh. It's not a monetary penalty, I think that will bother people, but it's a 2 years imprisonment. Perfect. Board of Directors. Ram and I were actually discussing this at lunchtime also on Board of Directors, and how do we read provisions of 152 and 149 together, specifically in the context of independent directors. Just to put the entire discussion in context, 152, 6, 7 are basically in line with 255, 256 of the old Companies Act. We basically said that directors can retire by rotation. The New Companies Act very clearly sets out that 2/3 have to retire by rotation of the total number of directors, but the denominator excludes the independent directors. So there is no requirement under the New Companies Act of independent directors having to retire by rotation. It also clearly goes on to state that independent directors can be for a term of 2 years, or 2 terms of 5 consecutive years, which is then under section 149 of the Act. The question that we've been asked, which we were also discussing, is, so what's the position of independent directors today of a public listed company? Do they have the blessing under the old Act? Do they have to be reappointed or nominated to be reappointed? Should they be terminated and appointed again at the AGM? What's the process to be followed? Just want to draw your attention to 152(6) of the 2013 Act to answer a question that's been asked to us quite often. It very clearly says where the directors, whether appointed under this Act or any other law for the time being in force. So for the way we are reading it is the fact that if you have an independent director who's in the middle of a 5-year term, there is no requirement to reappoint them per se. You just need to make his appointment in compliance with the provisions of the new Act, which you can do by a simple resolution in your AGM without having to amend the terms of their employment. I think that's the best way to read it without disrupting the independent director's position out there, without basically ruffling the board as such. We've spoken about liability in the previous session, so I'm just going to jump over it unless anyone has any specific questions. Um, 185, 186. 185 is a prohibition. We need to keep this in mind. 186 is a permission in specific situations that's been granted. So 185 and 186 have to be kept in mind in the context of what they are. It's always a question, and it's there in the brochure also. Which one do we have to comply with? I don't know what the MCA's view or ROC's view is going to be on this, but if you read the provisions of 186(1), which starts off with the words "without prejudice to the provision anything in the Act," that only applies to subsection 1. Right? It does not apply across the board, just to clarify that. If you read 185, which is a saving provision, which saves any other provisions of law in this Act, right? So that in effect has the effect of saving 186. What's the confluence of these two legalisms that I just said? To our mind, at least, the confluence of these two is that both of them are independent tests that have to be satisfied. You want to talk in the context of giving a loan to a director, you need to satisfy 185 and you need to satisfy 186. If you say that without prejudice applies under opening paragraph 186, applies across the entire statute, you're basically not giving effect to 185, which was never the intention of the regulator in our view. So if you have to give due sanctity to that, the only way to read it harmoniously is to give effect to both. So therefore, like I said, for example, a loan to director will have to satisfy both. The reason I jumped in that because I saw a whole bunch of questions surrounding that, so I just thought I should clarify at least what I believe is the correct answer. Obviously, we'll have to wait and see what evolves from the ROC and the MCA. Just to put it in context again, no loan or security to a director or any person whom the director is interested. Like I said, it is a specific prohibition. There are very specific exclusions out there where it's provided in the term of service or the scheme has been approved by special resolution of the member for a whole-time director or for a managing director. And if the company is acting in the ordinary course of business and not less than RBI rates. The previous presentation touched upon that. 186 is the equivalent provision of 372A. It's pretty much remained the same. I think the key deviation that's there in 186 is the holding private exemption has been done away with. Sorry. Not good with this, sorry. The holding company relationship, the private company and the holding company exemptions that were there have been done away with. So therefore even those relationships will have to be within the fold of 186 and therefore will have to comply with the 60% limit, the disclosure norms that are there, the EGM disclosure has to be there, so on and so forth. A question that's often asked is not only in this case but in a number of other cases, what do you mean by ordinary course of business? It's not the only place that ordinary course of business finds a mention under Companies Act. Ordinary course of business. Has the company been historically doing it? Is that the industry practice followed by that company? Does your objects authorize it? I think if you satisfy both that threefold test, I think it depends on what the answers are, but I think that's the three questions that you really need to ask to figure out whether it is in the ordinary course of business or not. The other point that I want to touch upon is also, I think, in interested directors, again touching on 185, 186, it said that where you're accustomed to act on the instructions of directors. I think it's there in subclause E of the definition of interested directors. Yeah, it says any body, corporate, board of directors, managing director, manager who's accustomed to act in accordance with the directions or instructions of the board. What do you mean by this? What do you mean by accustomed to act? I think on this one I'd just like to at least share our perspective again. The Vodafone judgment actually spoke about this a little bit, and actually very clearly, I think it was Vodafone, sorry, but very clearly said just because you have common directors or there's a commonality of function, albeit a holding or a parent company or subsidiary relationship, that is not enough. You actually need to be able to, from a subsidiary perspective, for example, a subsidiary has to be doing independently and not just following the instructions of the board or of the parent above. So it's actually a factual determination that has to be done. There is some case law on it. I don't know whether it's in that context that the clause will be interpreted, but I just thought I'll share that perspective with you. Provisions on fraud and SFIO, sorry, I don't have many issues on this. This was just part of my original topic, so I've put them down here. So if you don't mind, I can just run through it, but I don't have any issues to highlight or any special insight to share with you on any of this. Fraud, for the first time defined under the 2013 Act, is defined as any act, omission, concealment of any fact or abuse of position committed by any person. There are penal consequences that have now been prescribed. And I think that's a common thread throughout the entire Companies Act. Like I said, they realized that the penalties under the old 56 Act were too lenient. It wasn't enough of a deterrent value to companies to try and do cute and innovative structures. They've very clearly put the noose around the neck of the directors and the promoters in terms of criminal liability, as well as the monetary penalties have been increased a lot. Again, in this case, it's 3 times the amount involved in a fraudulent transaction. SFIO has now been conferred with statutory status, which wasn't the case earlier. It was an independent body that was there, which was issuing notices and investigating acts of companies. But now it's been granted statutory authority. It's given broad ranging powers to actually investigate. The SFIO officer actually is almost as good as an inspector under the CRPC in terms of the powers that the SFIO officer has to investigate. Yes, it's a cognizable offense of fraud, and like I said, the SFIO officer has powers to arrest. My dear colleagues spoke about the obligation to report or not report. I think the answer from all of our perspective is very clear. There is no two ways about it. If you don't want to be in jail, the answer is quite simple: report. That's it from my perspective. I'll be happy to take questions along with the other panelists later. Thank you.